Good afternoon, everybody. My name is Luis Costa, and it's my pleasure to announce the keynote of today of our seminar, Digital Rights as Human Rights, Why It Matters and Where Do We Start? Our keynote is Ms. Judith Hauhofer, and it's my pleasure to welcome Judith. And as introductory words, I would say just couple of things about the title, the very title of our panel. So if we take it in two parts, so these two parts of the title, the first one, digital rights as human rights, we can just point that it's clear that more and more information technologies amplify some already known issues concerning rights in general, and poses other new challenges, surveillance, abuse of economic power, balancing rights, etc. The list is long. The relevance and magnitude of such issues is somehow reflected in this first part of the title. That is to say that taking rights, digital rights as human rights, so it's the first part. The examples in this direction are numerous, so we can remember the case law of the Supreme Court of the United States about the right to privacy, be the long development around Article 8 of the European Court of Human Rights, or more recently in Brazil, the recognition that privacy and informational self-determination are somehow outcomes of personality rights established in the Constitution. So, concerning the first part of the title, digital rights as human rights, yes. And then the second part, why it matters and where do we start? I must admit that the first time I read this second part, I posed myself the question, who are the we? We start, who are the we? So first reflects, I would say, more in a restrict way. If I think we as Brazilians, it's a kind of a problem. We have a kind of problem here. It's already particularly in this national culture, it's like invoking some kind of tabula rasa, putting ourselves in a position as if we in the state of a blank slate. This is relevant in the sense that if we are talking about human rights, which are meant to be universal, and the very idea of universality must imply taking seriously into account the reality of human rights as they are experienced in democracy, be in the global north, be in the global south, everywhere. So after this first reflex of considering we as Brazilians, I repel it. So this we cannot consider in a way, in such a strict way. So we should, I think, really demand a necessity that we consider we in a positive way and in a broad as possible way, including Americans, South Americans, North Americans, Europeans, and Asian. So the question has a kind of candor or openness, which I think it's necessary and very helpful, so we can develop the protection of human rights as a whole. So it is in this positive communitarian spirit that I have the pleasure to present Judith Hauhofer, our keynote speaker in this panel. Judith is the legal author of the Digital Freedom Fund, the DFF. She's qualified as a German Rechtsanwalt and a solicitor in England and Wales, and has previous experience in legal practice, legal publishing, and advising digital rights organizations on policy making and strategic litigation. Before taking up the position with DFF, she worked as a senior lecturer at the University of Edinburgh, where she pursued research and teaching in the area of data protection technology law. Judith is a founding editor of the European Data Protection Law Review She also serves as a member of the editorial board of the European Journal of Law and Technology. So without further ado, I give the floor to Judith Hauhofer. Be very welcome, Judith.
Thank you very much, Louis. And thank you very much for the very kind invitation and to allow me to speak to you today. I am doing what we're all supposed to be doing. I'm going to share some slides with you. Let me get this. So can everybody see this? Okay, whoops, and here we go already. Okay, thank you very much for the invitation, and thank you very much also for the very useful introduction, because of course when a European like me is invited to another continent to speak, albeit virtually these days, I think there is often, particularly in my area, there is often a feeling that we are going to bring a message of something, particularly in the area of data protection. And I think all the work that I have personally done over the last few years has told me one thing, and that is that actually is completely and utterly the wrong approach. And this is partly what I would quite like to speak to you about today. So the title of my talk is Digital Rights are Human Rights, the Emerging Global Consensus, also on a right to data protection. And I want to start with this idea of digital rights are human rights, largely because it is actually the mission statement of the organization I'm now working for, the Digital Freedom Fund. We are an organization, a European organization, that isn't directly involved in operational work of strategic litigation. We are a funder. We are funding European NGOs, digital rights organizations, who want to bring digital rights court cases. And the digital rights are human rights is essentially, as I said, our mission statement. It is on all of our tote bags, which you will see in the little photo on the side. And it is a statement that really, when I heard it myself for the first time, I felt it's almost like one of those things where you think that shouldn't need to be said. You know, this should not be controversial, because we are now several decades into this digitized environment, this cyber environment, and it should probably be clear to most people that the human rights that we have relied on for a while, several decades, really since at least the Second World War, they have not been completely revamped by the internet. But what we probably have to do is we have to think about how these human rights can actually be exercised in the digital environment. So my first opinion is probably a little bit controversial, and that is that the internet has not changed everything. And in a way that comes back from my teaching background, because I had a colleague and I, for a few years, we taught a class together in IT law, and we actually had sort of a jokey rule with our students that anybody who wrote the sentence, the internet has changed everything, in one of their exams or their essays, they would immediately get a deduction, a reduction of the mark, because it is such a broad statement. What I would like to talk about, however, is the way in which this idea of human rights in the online environment and the digital environment is currently framed, the way in which the narrative is framed. And I'm calling this framing the narrative the neoliberal edition, because I think it is very important for human rights advocates to really very much question or interrogate these narratives, and to make sure that we are not inadvertently drawn into a sort of framing that actually is potentially counterproductive. So the framing that we are seeing at the moment, definitely in Europe and probably in many other areas of the planet as well, is that we are looking almost at something of a conflict. On the one hand, we are looking at what is the undisputed benefits of digitization and new technologies, or at least what those benefits could be. And of course, there are already discussions about that as well. But at the same time, we are also having this idea that there is a fear that continued strong commitments to digital rights will actually harm innovation and affect economic development. And I think this is an idea that we definitely need to interrogate, because the question really is whether we are looking at a complete conflict here, whether this is an either or if there isn't a way in which digital rights, and particularly in my case, because that's my area of expertise, data protection, are not in conflict with innovation and economic development, but can actually be used to support and reinforce these objectives. So when we're talking about regulating the digital environment and the role that fundamental rights, human rights play in this context, I generally say, like a teenager, it's a bit more complicated than that. And what I'm really drawn to as a framework of interrogation in this context is an argument or an approach that has been used by Julie Cohen in her recent book, Between Truth and Power, where she compares the transition that we're currently finding ourselves in from the industrial to informational capitalism to the previous transition that we basically were undergoing as the human race, from agricultural to industrial capitalism. And what she says is that both of those stories are stories of movement and counter-movement. So in the same way as law, regulation, and in fact commercial and individual behavior were shaped in that earlier transition, they are actually playing out almost in the same way again in this current transition that we are now witnessing. And what she means by that, as I understand it, is that in terms of the movement, we are seeing this on sort of two parallel tracks. One of them is the economic developments of what this actually means, this new form of capitalism, for a want of a better word, this new political economy that we are living with. And then how the law is used to regulate, to govern this new form of economic activity. And what she has identified is that the movement part of these transitions often can be observed in the form of powerful actors. So in the agrarian capitalism or in Victorian, in that first transition, so industrialists, people with access to certain resources, be that mining resources, be that land, be that labor, they essentially very quickly managed to utilize the law and legal provisions to actually support their own position. Julie Cohen calls this legal entrepreneurship, and that basically means that there was a way in which law was used to actually enable these kinds of activities. And I think that is something that we are very much seeing and have seen over the last 25 years, in particular, when it comes to the regulation of the internet, of the World Wide Web, of the use of data, in particular in the beginning. Again, I can speak from a European perspective here, but I'm old enough to remember the first wave of regulation at European level, which was about in the early 2000s, when the European Commission published a range of directives that essentially dealt with a lot of issues that had to do with this new digital environment, this digital economy. And what they were trying to do at this point in time was to actually support the development of this new environment, to support this new digital economy. So there were a lot of rules that were actually slightly less restrictive on those that were active in it commercially than they probably would have been in an offline environment. And that has created, to a certain extent, an expectation that this is going to continue. But what we are also seeing, and what Julie Cohen argues we have also seen in the earlier transition to industrial capitalism, is that there is a tipping point at some point if we do create, through this approach, a power imbalance between those who have essentially access to resources, who do carry out the innovation, who do produce the new commercial wealth, essentially. And where that activity imposes or creates pressures on individuals. So every action, it could be argued, has an equal and opposite reaction. And what we have seen in this earlier transition, if you really think about it, is that there were labor movements, there was a development of new ways of sort of security for individuals that were working within this new form of capitalism, industrial capitalism. We were seeing the development of social security systems, of pension systems, of health and safety, of employment laws. So there was a lot of law in that counter movement part of the narrative, essentially, that pushed back against this earlier form of governance that really was just designed to allow entrepreneurs to do their thing and to do this as well as possible. Once they had established themselves, once they had established this new form of economic activity, the second form or the second wave of governance of legal rules very much provided a counterpoint to this original form of almost laissez-faire kind of regulation. And I think what we're seeing at the moment, the situation we are finding ourselves in now, and we can probably observe this in an awful lot of areas when it comes to the digital sphere right now, is that we seem to be reaching some of these pressure points, and that we're seeing increasing civil society mobilization. We're seeing increasing unionization, for instance, in the area of gig workers. We're seeing increasing advocacy. And of course, I have to mention this because this is the area that I work in. We are seeing the use of strategic litigation to actually protect individuals' fundamental rights. So we are sitting at the moment, I suppose, very close to this tipping point that Julie Cohen has described with regard to the transition that we are looking at. So why does this matter now? I want to go through a number of different areas, particularly with regard to the use of personal data. And the reason why I think this matters now is that the protection of digital rights has been made more challenging as a result of technological advances, as a result of this new data extractive business model or business models that we are witnessing right now, as a result of emerging digital economies generally, and because these data networks that we are looking at are globalized. And what this means for civil society activists and advocates, human rights advocates, is that we potentially need to reframe, as I said before, the narrative, this neoliberal narrative of a real conflict between innovation on the one hand and human rights on the other hand. So if we're looking at technological advances, what we can observe is that we are all, without fail, in every country, live increasingly datafied lives. And the questions that we need to ask ourselves in this context is really, what and how are we using, what do we use technology for and how are we using it? And at the moment, I think a lot of questions arise, particularly in the context of personal data processing, but also in the context of the use of AI and machine learning and all sorts of other technologies. Are we using these technologies for, with, or against humans? So there are a number of examples that one could look at here, but one of the examples that is very close to my heart, because at DFF we have literally just done a speaker series about what we call the digital welfare state. It's the use of AI in a welfare context. And we have looked at a number of different examples from different countries as part of this speaker series. And the common denominator that we have seen is that oftentimes machine learning, AI, and technology are used in the context of welfare benefits, the allocation of resources, and so on, not only as a way to improve the services, for instance, to make them more efficient, to make it easier for individuals to access what they are entitled to, all of this sort of stuff, but very often also as a cost saving. And if we're looking at it like this, what we have also observed is that this cost-saving element can very quickly take over. It can very quickly take over the thinking of public departments, public services, and so on and so on. And that is a problem, because I think when we're using technology, we really need to ask ourselves, is this technology used for humans, with humans, and for humans' benefit, or is it actually, ultimately, does it have the effect of making it harder in this context, for instance, for individuals to access the benefits that they are entitled to? And we have seen a number of cases where that actually has been the case, where these benefits have been, where it has been made more difficult for humans to actually access services, public services, to access resources, and so on and so on. The second question that we have to ask ourselves in the context of technological advances, I think, is, are we changing technology, or is it changing us? And I've got two examples for this one. The first one, again, comes from this digital welfare state context. And this is that there is a real argument, and there is quite a lot of empirical research to back this up, that algorithmic bias exists in decision-making. And what I mean by that is that if you are using, let's say you are working for a public service, and you have to decide, for instance, who gets care services, social care or healthcare or something like that. And originally, this decision would have been made on the basis of certain criteria, but by individual humans, by civil servants, or by people who are involved in this. What we're increasingly seeing is that technology, AI, is actually used to make suggestions and recommendations about resource allocation. And although even in contexts where this is only supposed to be recommendations and suggestions, we are finding that humans who are then working with these systems increasingly distrust their own judgment and actually replace the judgment of the technology for their own judgment. So rather than the technology working for us, we are being trained by the technology to think differently and to replace our own human judgment. So I think this is something that we at least have to be aware of. This can, of course, be useful, for instance, to create equal treatment, to avoid discrimination, avoid bias. But it can also, if the technology is, if the training set is discriminatory itself, then what can actually happen is that the individuals who work with the technology can be sort of retrained as making discriminatory decisions. So this is something that we have to bear in mind, because this means that technology might have a more significant and more negative impacts on certain marginalized communities that are already living with less power in societies. The second example that I have in this context is actually one that is very, very new. I don't know how many of you may have seen this in the last few days on Twitter, but there has been a lot of murmur on the interwebs about self-driving cars and the difficulties that innovators have had with actually creating these self-driving cars, and whether or not they are safe to be let loose on society. And one of the things that one of the points that has just been made was that this would all be so much better if, for instance, cyclists or pedestrians wore beacons on their person at all times, so that the cars could read those beacons and could actually thereby avoid a collision with a bicycle or a pedestrian. Now, that is an interesting thing, because this actually puts restrictions or puts obligation on individuals, really, so that rather than creating a technology that takes into account the fact that humans exist, that humans move through the world, whether on foot or on bicycle, and that the technology can only be seen as safe if it can actually deal with that very existential fact. We are now looking at a situation where there is seriously a suggestion made that humans should change so that the technology can work in its current state. And I think this is another thing that we always need to bear in mind. Are we changing the technology, or is it changing us? And the third question that I would like to highlight with regard to technological advances and where we need to sort of challenge ourselves is this conflict between what police often, law enforcement often calls the capability gap, i.e. all the things that either certain services can now no longer do, or things that individuals can now do that make it more difficult to govern them, versus things that we will never be able to do, and probably for good reason. So one of the examples that I would like to bring up here is that particularly in the context of surveillance and law enforcement and crime prevention and prosecution, law enforcement services often argue that they need to have more powers of electronic surveillance, because criminals can now do all of these sorts of things online and in back chats and using encryption that they could never do before. And because this is an arms race ultimately, and because criminals have basically gotten better tools, the police needs them as well, so to speak. And that is correct on the one hand, but on the other hand, I think we also have to bear in mind that these electronic surveillance technologies that rely on the use of data in many ways are now also enabling law enforcement services to do things that they were never able to do previously. So, for instance, if we think of the collection of communications data, i.e. not the content of an email, but the when and where it was sent and who the sender was and who the addressee was, if we compare that with an old-fashioned postal letter, then it was not actually possible for the police in most cases to find out who sent the letter, who put it in what post box, and where it ended up. If they intercepted the letter, then that was it. But this whole communications aspect of it, that was not necessarily part of the information that law enforcement would have had access to. So there is a question of this capability gap, and where there is again a tipping point between a justified sort of, retooling and what could also be seen as swinging the balance in the other direction, so to speak. Other examples for this is also things that we just weren't able to do previously. Okay, so we're currently looking at things like emotional AI, where technologies can actually find out just from watching your face, or maybe from the way you're typing, whether you're depressed today, or whether you are suicidal, or whether you are in the mood to spend a lot of money on Amazon or anything like that. We have face recognition. We have this idea of constant tracking of our online behavior, what we're doing, what websites we're looking at, how long we're spending on these websites, which ads we are clicking through on, all of these sorts of things. We have a near constant identifiability that we'd never had before. So one of the examples for this, for instance, is digital payments. As long as we pay with cash, payments are essentially anonymous. You go into a shop, you buy a packet of cigarettes, you pay with cash. Nobody knows who you are unless you go to this shop every day. And there is a certain anonymity in this. If you, however, pay by digital payment, then this is traceable, you are identifiable, and this leaves a data trail that we never actually had to deal with in the offline world previously. Similarly, there is now a permanent record of everything. So there is a lot of talk about children, growing up on the internet, essentially from the ultrasound photo that their parents put up while the mom is still pregnant, all the way through to the teenage years and all the stupid things that we did. And I am old enough again to be relatively lucky that it's probably only me and a handful of really, really good friends remember all the stupid things that I did when I was 16. But today's youth no longer have that option. Essentially, a lot of their lives is entirely online and is constantly and permanently recorded, and the internet is forever. So there is essentially something that we are currently creating that goes way beyond what we used to have in terms of, the amount of data that is available, the context in which this data can be accessed, the purposes for which it can be used. And I think this is something that we also have to bear in mind. The reason why I'm raising all of this is, of course, that if the threat model has changed, then potentially the governance needs to change. And this is, again, why we are looking at digital rights as human rights. So we have created an environment where what would have been controversial a few years ago has been completely normalized. And I don't know how many of you may have seen the ACLU pizza advert. There is a video that goes around. You can probably find it on YouTube. where basically somebody orders a pizza and they have all this information about them. Or I saw another video recently that I used for teaching for a few years, where somebody goes into a bakery and buys a loaf of bread, and they actually get asked, what their address is, and then they get asked, where have you come from? Where did you go? Where were you before you came in here? And where are you going now? And then the bakery assistant follows the person out of the shop and into all of the next shops. And that sounds so crazy, because this is not something we would tolerate in real life, but it is actually exactly what is happening when we shop online, because every online website, every website that we are visiting has trackers and knows what the last website was that we visited, and they know what the next website is that we're visiting, and this information gets constantly collected. So we have created this environment where what would have been controversial has been normalized. We just live with it now, and that is something we need to bear in mind. So this mindset of move fast and break things means that there is now a perception that any form of regulation of this new environment is an impediment to innovation and thwarts efficiency of technology. And that I think is this narrative that I would like to caution against, and that I think we need to challenge and we need to interrogate, because the real question is that really so? What we need to do instead is we need to focus, we need to question this idea of always focusing on technological fixes, while potentially obscuring underlying existing issues that have always been there. And the three issues that I would like particularly draw attention to are power imbalances that have always been there in society and that continue to be there, injustices and discriminations that is related to this, and also just the human condition, the pure way in which we all behave, and how we can be manipulated to behave in a certain way. And I think we have seen in many ways that when there is a human behavior that is generally seen as something that needs to be regulated in one way or another, that needs to be governed, there is now almost a reflex reaction in many cases to use technology and to use personal data to regulate it. So rather than really thinking about, why are individuals doing that? What are the origins of this behavior? They may be economic, they may be, based on other characteristics. There is now a rush towards let's use technology to actually address that. So we have this example that I already made with regard to increased police powers, but we also have examples of trying to address injustices and discriminations that have nothing to do with technology, trying to address this with technology. But as many people have said, the road to hell is paved with good intentions. And in many cases, this actually leaves us worse off than we were before, but also it potentially cloaks the fact that the real issues are actually underlying and are deeper than just the technology. One area where we have seen this very recently, and I can speak for Europe here, I'm not sure how this would have been in Brazil, is in how we dealt with the threat of COVID-19. So in the UK, where I lived through a number of lockdowns, the first rush actually was immediately towards technology. So we had this tracking app was developed at some expense very, very quickly. And in a way, this was useful. I'm not actually dismissing the idea of using technology to deal with the pandemic, but the problem I think that we saw was that there was an awful lot of emphasis placed on this, and not a lot of emphasis, or not enough emphasis, on actually trying to influence human behavior. And I think this is one of the real examples where we have to think about, okay, so is technology sometimes just something that we use to actually cloak, as I said before, what is actually happening underneath? And finally, another issue, I think, another problem that arises then in this context is that the more technology we are using, and again, I think we are all feeling it now, the more technology we are using, the more we seem to ignore the importance of trust that we need for that technology to actually be used efficiently and successfully, because a lot of people, again in Europe, probably, but also in North America, I think, are now actually very resistant to the use of any technology, for instance, in the COVID context. There is a lot of resistance to the use of COVID trackers. There is a lot of resistance to, I'm currently in Italy, so there is a big resistance to what they call the green pass here, which is the digital vaccination certificate. And the reason for that is because people are afraid. They are afraid that this is something that is ultimately going to be used against them in a situation where they have no power. So I think the other thing that we need to think about here in terms of why is this important and why does this matter is that we need to make sure that we take the people with us, so to speak. There needs to be trust in technology for technology to work effectively. The next point is that we are obviously looking at very new data extractive business models. And there are a number of different narratives here that I want to actually take apart and deconstruct individually. The first of those narratives is the one that is already well known to everybody, and that is that data is the new oil. And what this suggests is that data is this resource that's just lying around and that basically can just be taken. And that it isn't linked to anybody. It is just this thing that, that can fuel something that we do, like our business activities. And a friend of mine and colleague from the UK, Chris Marston, he has actually developed a different metaphor for data. He says it's not the new oil, it's actually silk, and we are all the silkworms. So we are producing the data, and the data is harvested from us. And if you're looking at it like that, you can immediately see that there are human dignity issues involved, that there are issues of self-determination involved. And it is in that framing, in these metaphors that we are using to describe the situation, that we actually see how we can deal with this differently and where the priorities lie. The second metaphor, the second narrative that I would like to pick up is that this idea that data can be mined freely by everyone. That is closely linked to that first narrative. And of course, the question, if you are thinking about data not as oil in the ground, but as silk that is produced by a human being, you can immediately see how one is almost justifiable data mining, but the other one is exploitation. And I think this is, again, something that we need to think about. What role do human beings actually play in this whole use of data for commercial purposes? The third narrative is that data volume can be increased through engagement. This is what Shoshana Zuboff calls behavioral surplus. And what she means by that is that not only do businesses take data that we produce anyway, and they just take it as it is, what they are now doing is they're actually farming us. They are encouraging us to produce more data. So a lot of online businesses are actually focusing very much on engagement. We are talking about the attention economy. We are a lot of the reasons why social media, for instance, social media services are set up the way they are set up is because, people want to keep us online for longer, because the longer we are on there, the more we are engaging, the more data we shed. And it is that data that is the resource from which businesses derive their revenue. So the question here that we have to ask ourselves is this actually ethical behavior? Is this a kind of economy that we want to have? And the final final narrative, final metaphor that is related to all of the above is that data should be like property, that it should be ownable and tradable. And I think this is something that European data protection lawyers have resisted for a very long time, because it is a more rights-based approach that we are taking in Europe. And we have never really seen data as tradable property, but it's purely by practice and habit and by the kind of business models that we have seen in recent years, we have seen that this is something that is essentially just coming through, and it is just basically, it's becoming something that people just accept as a fact. And I think we shouldn't accept it as a fact. We should actually still challenge it and interrogate it. So moving on to the emerging digital economy, the next challenge, the question we have here is what's happening and who is in charge. And I think the easy answer to this is, or the clear answer to this is that, nothing ever changes, same as it ever was. Developed nations in this context, and both in the development and innovation of technology, but also in the regulation of technology, have clearly taken the lead. And there has been an expectation, and there has been political and economic and legal pressure that has required lower and middle income countries to follow that approach in many ways. So both in terms of the movement, the technical innovation, and the counter movement, the regulation, we have seen this kind of dynamic. And what this actually means is it's not actually always that easy, I think. So we can look both in terms of the technical innovation side and the regulation side to the benefits and the downsides of this. There is a clear benefit also for many countries in the global south of technical innovation. Of course, there is. There is also an undeniable benefit in good regulation, in good governance of that technology. However, what we also have to bear in mind is that this forces a reprioritization of government resources in many cases that actually cannot necessarily always be compared to what is happening in the global north. So if a country like Canada, for instance, currently discusses whether or not it wants to adopt a new Commercial Privacy Act, then that is a different sort of ballpark, shall we say, compared to if a country like Namibia does this. Because reprioritization of government resources in Namibia means potentially that these resources are not actually available to bring water to remote regions or to put electricity or telecommunications infrastructure down. So there is a big issue of priorities, of resource allocation here that needs to be considered. But there is also the other question of, are we looking at a new age of colonization here? And again, this can happen on many levels. My organization is currently looking at decolonizing the field, decolonizing ourselves. And I think the first question that we are asking ourselves here often is, what does this mean? What does colonization actually mean? It means it's extraction, but it also means the imposition of rule systems that are not necessarily native to the society on which they are imposed. And again, at a human rights and data protection level, this can mean two things. One of them is that, of course, there is a real risk in many cases in countries that have no, say, data protection rules, for instance, that big international companies move into those countries and harvest data in exactly the way that I have described, and can do so more easily in those countries because there is no protective framework. At the same time, we have to ask ourselves, I think, whether, frameworks, legal rules that have been developed, within a cultural framework, within a legal framework of the global north, whether that is always the ideal and exact right way of governing different countries, different cultures, who may have different priorities. And I think this is another thing that we really need to think about in this context. Because what we are doing here, and this is the final point on this one, is that we are ignoring cultural differences in many cases. And one of the reasons, or one of the areas where I have been able to observe this, is I've done quite a bit of work in Africa recently, in the last couple of years. And there is a very different understanding of what human rights actually means, what fundamental rights actually means. There is a much more collective approach to this idea of human rights, and a lot less individual rights based. So as in, my rights rather than my community's rights. And I'm going to come to this idea of individual versus collective rights in a minute. And finally, then, looking at the last sort of element of this new development is that we're looking at globalized data networks. So these innovation processes that are happening, they are no longer happening at national level. They are mostly happening at international, global level. And the question that we need to ask ourselves here is whether it is too late now to unscramble those acts, because really what we are already seeing is that infrastructures that have been built have largely been built on the basis of these globalized networks. We are seeing an increase in global trade that involves the processing and cross-border transfers of personal data. So, for instance, again, from a European perspective, a lot of the big tech online providers, for instance, are US companies who are now working with the data, personal data of EU subjects, data subjects, and with the personal data of data subjects in all other countries and continents. So there is an increase in global trade that involves personal data. There is also changes. There has been a move to a cloud-based model in many ways. So this is something that we have been dealing with recently as a digital rights organization. So we are doing seminars, we are doing field building events, and these are usually very collaborative. And because at the moment everything is virtual, everything is online, we have been looking for collaborative platforms that we can use. But because we are a digital rights organization, we are trying to stay clear of platforms that are actually provided by the big tech companies, because that would be kind of counterproductive to our mission. But it is actually really difficult to find alternative platforms that we could use for all and get all the benefits out of, but that do not then come with the downsides. And those downsides, of course, are loss of control and loss of data sovereignty, because stuff is then in these platforms and you may or may not have access to them in the future. And finally, of course, the final part of this is that this has an impact on regulation. So where the law has always been a creature of nations, regulation has always been mostly national with some regional harmonization and some international cooperation. What we are increasingly seeing in the context of the internet is this almost this wish for a world law. So when I was still teaching, my students were generally just saying, well, the solution would be to have a global data protection law. To which my answer generally was, well, good luck with that, because we're not there yet. It's not that easy. But the problem, of course, is that we are seeing this impact on regulation, and that more and more of the regulation, in order to work, actually does have to happen at the regional and the international level. So bringing all of this, together, the question then is, data protection is a human right? Yeah, of course. And here I have hopefully an uncontroversial opinion. So while the internet has not changed everything, I feel that the EU data protection framework has changed everything, and whether for good or for ill, but it has definitely made an impact. And again, that is something that I would quite like to interrogate here. The facts of the matter are that the EU data protection law framework is probably the oldest, in the global context. It has created, for good or ill, a governance framework for the processing of personal data for EU data subjects. It has established this by establishing data protection principles, data subject rights, enforcement ideas, and those have been sort of transmitted to other regions as well. It has some quite basic ideas. One of them is that it binds public and private entities equally. That is not the case in many other countries. It has a rights-based focus, and it uses trade. The EU uses trade to create economic, political, and legal pressure on other countries to adopt similar measures. It does this most recently through the extraterritorial application of the GDPR and through cross-border transfer restrictions, which have a much longer history. So what we have seen is that it has now done this not once, but twice. And this is why I brought this biblical quote: what has been will be again, what has been done will be done again. There is nothing new under the sun. And what we can see here is actually the way in which this framework has shaped subsequent developments at a global stage is actually almost the same in the first generation of data protection instruments and the second generation of data protection instruments. So you can see on the left-hand side the way in which the early national data protection acts actually have come, sort of gone global. And then in the right-hand box, you can see that when the EU decided to change and to update its data protection framework, all the other areas have followed suit. Okay, so there is a real pattern emerging here in this context. And that is a big responsibility, and it is a big question that we have to ask ourselves in this context as well, because it is power ultimately to do that. And what we have seen also are current and national initiatives. And I've picked up some of the really big ones here, California, that you will be aware of, Canada, China, but of course, Brazil has adopted a data protection law. And some smaller countries have adopted data protection law. And in many cases, they have done that not necessarily with a view to, because it's definitely a bottom-up kind of development. I think this is really important. A lot of the time, these laws have put in place to enable trade, to facilitate trade with the EU in this context. And that means that there is a big responsibility here on the global north, really, to not abuse that power and to make this less of a one-way street. One of the interesting things, however, is that although we have all of these developments in the development of data protection frameworks, the recognition of a right to data protection as a fundamental right is as yet largely missing in national constitutions and international human rights conventions. So we have some of them. It's not for want of trying. We have some of them. We have attempts to bring this at a more global scale. And we, of course, have the right to privacy in many ways, but we do not necessarily have the same acknowledgement of a right to data protection. And that, I think, is one of the things that we need to bear in mind in this context, that we need to understand and we need to ask ourselves to what extent this is actually something that we want, and to what extent this is something that we need. And this is what I want to focus for the last 10 minutes that I have for this talk. I think there are a number of challenges with regard to this global acknowledgement of a right to data protection. I've listed 5 here, and I'm going to go through them one by one. The first of them is that we are still not entirely clear, I think, what the difference is between the right to data protection versus the right to privacy. There are probably 3 different attempts or 3 different approaches that we can see. One of them, the first one, is that data protection is merely a subset of the privacy right. And that is maybe an old style, old-fashioned kind of attitude, which was also potentially included in the first generation data protection instruments, because a lot of them, including the EU Data Protection Directive and the Convention 108, actually referred specifically to the right to privacy as the thing that they wanted to protect. And in the US, of course, we have this discussion about information privacy being a spin-off almost of the privacy rights that they have. The second approach is that the right to data protection and the right to privacy are distinct but complementary. They both seek to achieve some higher order values or protect some higher order values like dignity, autonomy, control, and limitation of power. But as Paul Hurd and Sergey Goodward have called this, privacy, the right to privacy, is a tool of opacity. So you can conceal things that you don't want the world to know. Whereas data protection is really a tool of transparency, meaning that people who use your personal data need to be open about it so that you know what's going on. What one could also argue is that there is a different protective scope. And this is where I was really, really intrigued and encouraged by learning about this recent Brazilian decision in the census, the census case that you just had. Because what that does is it mirrors almost exactly an earlier decision that we had in Germany in 1983, which was also on the census, which created this right to informational self-determination. And I think the idea of creating this right to data protection from existing rights, from existing personality rights, and also the reasons why they were created, there's a really big parallel between those 2 decisions that I would love to do some further research on, actually. And the final approach is that this distinction is that these rights are distinct but heavily overlapping. And that is actually the one that I'm personally following. So data protection, I think, serves a multitude of functions. It facilitates individual rights, including privacy, but it also facilitates collective values, and I'll come to that. And the added value really here lies in the protection from personal data-related abuses of power, I think. The next issue that we need to consider is the role of data protection. And here, I think, is something that is not yet sufficiently acknowledged in many countries, including the EU. And that is the role of data protection as an enabling right. What we often see is data protection being presented as a right that prevents us from doing stuff. So it's basically set up as a conflict between data protection and security, data protection and public health. In the recent COVID pandemic, data protection and freedom of expression, data protection and equality and justice. And there are good arguments for this in many cases, but I think what is not sufficiently understood in many ways is that there is also a role that data protection plays that enables all of these values. So for instance, if we're looking at security, it very much depends on our threat model. So if we are trying to be secure from an external terrorist threat, then yes, the fact that we have more control over our personal information might actually hinder law enforcement and security services in doing their work. But if the threat is actually the security services themselves, as they are sometimes in authoritarian regimes, then privacy is actually very important to protect yourself from that security threat. So, for instance, in the GDR, the German before reunification, East Germany, there was an immense threat to individual citizens through the use of their data by that government. And privacy would have helped these individuals. So there is something that we can learn from that. Similarly, public health, I think with regard to the use of technology and the use of data in fighting the pandemic, what we have seen is that, yes, of course, we need to give up potentially our data, we need to donate our data to this cause, but at the same time, we also need to do so in a well-protected and well-regulated way, because if people do not feel safe to donate their data to this cause, then they will try not to do so. And that will actually harm the public health effort. As regards freedom of expression, what we have seen is that, yeah, there is often this idea, often in a context of covering a celebrity's shenanigans, that, you know, their privacy actually sort of affects freedom of the press or affects freedom of expression. But I am really intrigued by what Neil Richards, a US scholar, calls intellectual privacy. And what he says is that freedom of expression does not just involve the speaking, it also involves the thinking about what you want to say. And it is this thinking, you know, this headspace that you need to make up your mind to figure out where you are. This is where you need privacy. This is where you need data protection. And finally, of course, with regard to equality, justice, and non-discrimination, we can see that, again, sensitive personal data related to particular characteristics can obviously be used to bad effect, but they can also be used to good effect. And again, data protection is actually relatively agnostic about this. So we do not have to see it as a conflict that is set up. We can also see it as, you know, working together. Most importantly, though, and I think this is what both the Brazilian Constitutional Court and the German Constitutional Court in their census decisions have said, is that there is a need for data protection to protect political and democratic participation. Then I think it was the right to assembly and association back in the 80s that we were thinking about. Now we're thinking about things like political micro-targeting, the ability to manipulate people on the basis of what we know about them. And this is another one that we want to see. Right, I'm seeing that I'm really running out of time already. Okay, so let me come to this final question for me that is also really important, and that is seeing data protection as an individual or a collective right. And I've touched upon that already beforehand. There is a very strong focus in Western liberal thinking, I think, that human rights are specifically a right that protects the individual. You know, it is essentially an individual defense right against the state. And I think this is, again, a very much a global North way of thinking, very much a classical human rights sort of approach. And it is not necessarily an approach that is echoed in all other cultures and in all other countries. And I think one of the things that we're currently seeing is that we have a lot to learn here in the global North about collective rights, collective sort of priorities here. What we are seeing, the downside of this individualist approach that we are seeing in Europe at the moment, and we've literally seen it in the UK today, is that when we want to prove that our data protection rights have been harmed, we must show that there is a verifiable detriment to us as individuals. And in terms of something like data protection, that's actually really difficult to do. How do I prove that the fact that Facebook uses my data actually harms me? What is the harm? How do I define this? How do I quantify it? Well, what do I actually get out of a lawsuit, of strategic litigation that I want to bring here? What we actually acknowledge and what we actually see is that it is not the detriment to the individual that is the problem in many cases, but it is the collective and societal harm that we are seeing when the individual data or the personal data of a lot of individuals is processed. So it's not my own harm, my own detriment that I suffer. It is the fact that all of us, all of our data is being harvested, farmed, processed, however you want to call it. And what comes out of that, the shift in the power balances that we have seen that comes out of that, that is the harm. But that is a harm that is very, very difficult to litigate if we're looking at data protection as purely an individual right. So unlike privacy, however, the right to data protection can be conceived as a collective right. And I think this is something where the Global North has much to learn. What we can actually learn from other countries is to really look at this as a communitarian, in Africa they would say Ubuntu kind of way, where we really have to look at the effect that processing of personal data of many people has on society as a whole. And I've got a few case studies here that we could use to clarify this. One of them is health information. So if I, for instance, let's say I do a DNA test just for the lulz because I want to find out if, there is anything in my past, who am I related to, all of this sort of stuff. So I go to 123andMe, which is one of those big DNA firms, and I sign the waiver, which allows them to use my DNA test results for research purposes. And I get my test results and I'm happy with it. Nothing much happens. But if 1,000 people do this, and if that data is then aggregated, and if certain conclusions are drawn from that data, for instance, about susceptibility to certain health risks or something like that, and those results are sold to an insurance company, then that could actually affect not just my rights, but also the rights of everybody else who's never done a DNA test. But because when they come to try and get insurance, they maybe fulfill a similar pattern, they would actually be brought under this. And the risk of discrimination here is really, really big, the risk of discrimination and exclusion. The other thing also is this idea of repurposing. So often with personal data, there is a certain critical mass that if you have that, you can do stuff with it. And if I am one of the people who helps a company or a government department achieve that critical mass, then what that also means is that any subsequent uses of that data can also not just affect me, but also everybody else who has not helped to achieve that critical mass. So this is, for instance, one of the discussions that we're currently having about the use of all the data that was collected through the COVID tracing apps now being used by both businesses and governments for completely different and unrelated purposes that we never actually envisaged when we agreed to have our data collected for the COVID tracing. And finally, there is this idea of micro-targeting. I think this is another really good case study. So that when we are looking at how we describe individual harm, where does the harm lie in the fact that Facebook knows so much about me that they can possibly serve me, or that their algorithm will serve me content that will polarize me, that will take me away from my community, that will make me more angry, that will make me vote in a different way or not vote at all of these kinds of things. So there are real risks here, collective and societal harms that have nothing to do with my rights as an individual, but have everything to do with an idea of personal data as a commons. So something that is subject to stewardship rather than ownership. And finally, I would like to talk about enforcement. So as I said before, I am working for an organization that funds strategic litigation in the area of digital rights. And that, of course, includes the enforcement of data protection rights. We are directly, ultimately, through our funding efforts, supporting the enforcement of the GDPR. And the GDPR as a legal instrument has a dual enforcement track. It has on the one hand the administrative, regulatory, complaints-based track where the regulators decide if somebody has breached the law, potentially fines them, makes decisions that they can or cannot do certain things. And it has the judicial track where individuals have the right to take controllers to court, to sue them for damages, for compensation, for omission. So the enforcement of data subject rights, for instance. One of the words of cautions that I would quite like to utter here is that experience with the GDPR, as brief as it is so far, has shown that both tracks are necessary and complement each other. And the reason for that is that we have very much seen in Europe that regulators are subject to political and financial pressure, and that their political and financial independence is incredibly imperative. So what we have seen, what we are seeing currently in Europe is that because enforcement works at the national level, there are regulators who are more eager to enforce, and there are regulators who are less eager, shall we say. And of course, where you have a less eager regulator who is potentially subject to political pressure, who isn't adequately financed, for instance, that means that the GDPR is only as good as the paper it's written on. So it doesn't actually help you very much. So where that happens, individual and collective redress options are absolutely vital. But again, this actually takes us only to the GDPR sort of level of it. It doesn't actually take us to a fundamental right level. And I think there is a real difference. And this is the point with which I want to close. The reason why we need the right to data protection beyond just data protection frameworks as we have with the GDPR and with a lot of other ones, the reason why we need this as a fundamental right is that this actually enables judicial review of legislative and executive action in a way that the GDPR or data protection law on its own does not. And I am making assumptions here that people, and I should never do this, but there are a number of cases before the European Court of Justice named Digital Rights Ireland, Schrems 1 and Schrems 2. They are quite well known. Another one, Tele2 and Watson, which is dealing with surveillance. These are cases where the outcome is very, very significantly influenced by the fact that the Charter of Fundamental Rights, the EU Charter of Fundamental Rights, now includes a right to data protection. If that right were not there, this corrective, this judicial review of government action, of EU government action, national government action, would not be possible. And I think this is the most important added value that I can see in data protection as a fundamental right, that it actually adds a layer of checking of what the US calls checks and balances, of what we call in the Europe safeguards. And for that reason, I am very much in favor of data protection as a fundamental right. So in conclusion, there is benefit, as I just said, in conceiving the right to data protection as an independent fundamental right, independent from privacy, and also as an enabling right. I think that we do require global recognition of this going forward and in the long run. This is desirable for political reasons. It's desirable for economic reasons because we are all interconnected. And it is desirable for legal and enforcement reasons because, again, if the person who breaches the law is in a different country and I don't have a way to enforce the law against that person or against that company, then the law doesn't help me very much. There is space, very much space, and this is something that we really, really need to tell the Europeans, the Americans, the Canadians, and everybody who is currently dominating discussions about this. There is space for further developing the concept of data protection as a fundamental right, moving away from a perception of it as an individual right, and really embracing this idea of a collective dimension of this, and also of data protection as an enabling right and as a constraint on state power. There is a right to data protection is nothing without proper enforcement. So I think this is the other thing that we will always have to bear in mind, that, you know, just to have the substantive rules are not going to help us if we don't have procedural rules that go with it that enable us to enforce this law. International collaboration is vital in future developments, and this cannot be a one-way street. And I think the most important message that I generally take home with me when I go to different countries is that we have much to learn in the global north about different perspectives, different priorities, different requirements. And that's it. Thank you very much. And I'll hand back over to you, Liz.
Thank you very, very much, Judith. Very rich presentation. For me particularly, it resonated in a couple of issues, but I will not, for the moment, abuse of my position of host and making you a lot of questions. So we'll go to the questions of the public, and if it's okay for you, we could treat them 2 by 2. So just a second, please. So there is a mention in your presentation about technology with, for or against us, mentioned by a person named Vera. So what is the limit of responsibility among the 3 main actors, in this case, technologies, companies, governments, and users? So I think it's a question related to the regime of responsibility, and particularly these 3 actors. And another question, more broad. And the second one, how to deal with controversial information in the internet, for example, regarding COVID virus, feeding data systems with wrong information. I'm not quite sure about apparently there's an issue of responsibility issue also here. If you could please treat them both together. So more general, 3 actors, technology companies, government, and users, and more specifically, controversial information in internet, taking the example of misinformation about COVID.
Okay, thank you very much. Okay, let's start with the first one. Maybe, what is the limit of responsibility, or how do these 3 work together? I think it's a really interesting question, and I would never presume to have all the answers in this respect. I think what we need to do is to look at this in terms of power balances. So when I speak about this to my students, what I generally say is I talk about a triangle, a power triangle. This is generally what I do, which basically means that there are relationships between individuals and the state, between the state and businesses, and between individuals and businesses. And the power in these relationships is never equal. And the law essentially is, as in all cases, trying to create an equilibrium, try to address existing power imbalances. And I think that protection law tries to do the same in a way. It tries to address these power imbalances where we are seeing shifts through the use of technology, through the processing of personal data, because there have been shifts. Okay, so if we have, as a business, if you have more information about me than you used to have, you have a better way of marketing to me, which is another way of saying you have a better way of manipulating me into buying something. A legal response could, for instance, then be to protect me from this greater power by changing the rules to readjust this balance. Similarly, with regard to the relationship between individuals as citizens and the state, if a police force or a security force has more information about me now than they ever had, and I don't have necessarily a counterbalance, then maybe what we need is better safeguards, not necessarily preventing or prohibiting those tools that law enforcement and security services need, but to actually make those tools subject to stricter safeguards. And I think this is what we're seeing at the moment. So I cannot actually come to you with an answer of, who should have what responsibility. I think I'm a lawyer. I'm looking at this generally as in what can the law do to recreate an equilibrium, or to keep an equilibrium. This is not always perfect. The law is never perfect, and the law never works alone. There are always other constraints, as we know from Lessig, but what the law plays a role in this. And I think one of the things that we are seeing with technology and with the use of data is that there have been shifts in these power balances, and that we need to use the law as well as all the other tools to address those shifts in power balances to bring and maintain a continued equilibrium. The second question, how to deal with controversial information in the internet network, for example, regarding COVID. So I'm trying to explain how I understand this question, and if it's wrong, if my understanding is wrong, maybe you can do a follow-up or something. But so my understanding at the moment is, situations like, for instance, where we say to Facebook, all this anti-vax information is on there, all these conspiracy theories and other areas are on there. And because you provide the platform, you should now be the content moderator, and you should now make sure that this stuff doesn't get out there and that people don't have access to it. Now, this probably doesn't make me popular with business, but my attitude to and my approach to this has actually always been that it cannot be about content moderation in this context. It cannot be about, on the one hand, giving these platforms the power to share and to specifically micro-target this kind of content to individual users, and then take part of that power back by telling them, but you mustn't do it in this way, and you must make sure that you're not harming anybody by doing this. As a data protection lawyer who has worked on cookie regulation for a very long time, probably back since 2009 or something, when the new cookie regulation came up in Europe, my argument has always been that the real fundamental problem we are facing is not the targeting, it's the tracking. And I think one of the things that we are increasingly seeing is that it isn't even intentionally that we are, channeling information intentionally to people because we want those people to know things or to read things or anything like that. Instead, what it is about often is about engagement. So the platform and the platform owners are often agnostic to both the harm they're doing and the benefits of channeling information. From their perspective, this is merely a business. So in order to keep you engaged as long as possible, they want to serve you with the stuff that is interesting to you, because if it's interesting to you, you stay on the site for longer. If you stay on the site for longer, you shed more data, they can find out more about you, that benefits their business model, they can make more money. And this is where the whole extractive data-driven business model essentially meets its own limitations, because if it weren't for that, if we didn't have that as a business model, then a lot of these downsides, a lot of these risks, these harms that we are now experiencing, be that political micro-targeting, be that disinformation, be that hate speech, a lot of this is actually because the algorithm works exactly as it is intended to work. It channels information to a willing recipient. So what we maybe really need to think about is that the way in which we want technology to work? And I think this is what I mean when I talked earlier about we need to challenge the narrative, we need to reframe the narrative. Because even when I speak to my students these days, what they come to me and they basically just take this kind of environment, this kind of technological infrastructure as a given. They don't question it anymore. They don't ask, is this the way that it should be? Are there alternatives? Are there other ways of organizing the internet, the World Wide Web, social media? They're basically just saying, well, this is how it is, and we need to deal with it. We need to address it. We need to mitigate the harms that are caused by it. And to that, I want to say, and I can say this louder now as working for Digital Freedom Fund and working for civil society, I can say, no, ask those questions, challenge those assumptions, change the narrative if it's the wrong narrative. So I think this is essentially what I would like to say here. It's not for me about telling the likes of Twitter and Facebook and Instagram and all the other ones to be better at moderating. There is an immense cost to moderating, both in terms of overblocking content and in terms of, where it is done by human beings, just the sort of what we are doing to these human beings by making them look at that kind of stuff all day. But there is also an immense cost of not moderating. And what we could actually do is we could just say, well, let's get rid of this data harvesting, this tracking-based data harvesting system, because then the algorithm has nothing to work with. And we could probably avoid a lot of the harms that we are currently seeing in that way. It is just that because that would have enormous economic impacts, it is not very popular with the technology companies that are employing this system.
Thanks again, Judith. Having said that, I ask a question for you. So it resonates for me both in the introductory remarks you made, but also regarding the enforcement issue. So I just make a brief quote of Marcia Sen's commentaries on Posner's Law and Economics. So, quote, legal arrangements can, of course, be useful for economic accomplishments, but this does not imply that any integration of economics and law must take law to be nothing that unserved of economics, judged only by how it serves economic goals, quote. So, we see in practice, at least me, my personal experience, that not only me, it's everywhere, okay? The financial argument or the economic argument is always the bottom line, or not always, at least plenty of time. You mentioned strategic litigation, your experience with strategic litigation and political and financial pressure, for instance, on data protection authorities, and how they react differently to those pressures. I wonder if you could talk a little bit more about your experience regarding strategic litigation, and how in practice you see this opposition with economics and law. And one more, it's a kind of the same question. Actually, it's a commonplace also, we take economics as a synonym of companies' discourse many times, at least in Brazilian context. So what company says is supposed to be economics, so they are speaking economics. So it's a kind of very strict manner. So we consider that economy is related to the whole society, not their companies are not the only ones who has a say on that. So all this talk, just to pose a brief, specific question, direct question, please talk a little bit more about your experience on that subject and how you feel this issue, sorry.
Okay, thank you very much. I think I agree with you that, again, the narrative at the moment is that economics means what big companies tell us it should mean. And that the law is often seen as you say, the servant of economics, in that it is supposed to be used, as we have seen with this very early round of internet regulation, that it is used to support business, it is used to support innovation, and that a lot of other things that it then fall by the wayside are seen as a cost of doing business in a way. I think that is slowly changing. I hope it is slowly changing, and I think we are closer to this tipping point that Julie Cohen mentioned about between the movement and the counter movement. And the reason why I'm saying this is that it's just difficult to see how much further it can get, I think, is the first issue that we have to address. So I had a chat with somebody from the UK Department of communications media, DCMS, communications media and sports. So they are the responsible department for kind of internet regulation. And we had a meeting, and then we, as it always happens, it goes into the coffee break. And the person I spoke to said to me, we had a meeting with Facebook guys last week. And I was just like, oh, how was that? And he was just like, it's insane. It's like we're negotiating with them like they are a country. We make concessions to them like they are a country. This is running now at the level of international diplomacy, and when you hear a government official say something like this, I think you get the feeling, you start to think that there is something very wrong with the way in which things have moved, because there's always been a mutual influence, of course. Businesses like citizens input into lawmaking, into governance, into rules of governance. And of course, government is interested in what business is thinking. And this should be, as I said before, an equilibrium. But I think what we are increasingly seeing is that if companies are acting like countries, if companies are making demands that are very clearly harming the citizenry of a country, and pitch their own benefit or their own desires and requirements against those of the citizens that the state is ultimately there to protect, then we are having a problem. So I think that is maybe the first point I would like to make here, that we need to be very, very careful about these companies and the power they have been able to gain in these relationships where we are now negotiating with them as if they were countries. The other thing, I think, and this is maybe more of a tangent here, but it's a point I wanted to make as part of the presentation, never got around to, was that when I started out as a technology lawyer, which is kind of all the way back in 1999, for a very long time, I used to say, I am more afraid of the state getting my data than my local supermarket getting my data. Okay, so my local supermarket in the UK was Tesco. They had this loyalty card. If you're using it, you got all sorts of nice benefits, money off, discounts, all of this sort of stuff. I'm sure you have the same. And it didn't worry me for a very long time that was happening. But I think what I became concerned about at some stage was that there is now almost a revolving door of data. So data that is collected in the private sector gets handed over to the public sector, but data that is collected in the public sector gets made available to the private sector. And I think this is another area where we really need to be very, very careful, because we are losing all distinction. I mean, we are all very much aware of the separation of power, between the executive, the legislative, and the judiciary. But I think there is also, and there has to be, a separation between the regulators and the regulated. And if basically two of those are in cahoots with each other, then we are having a problem, because that generally means that the third is going to suffer from this. And I think this is one of the really big risks that we are currently seeing. So both the increasing role of companies getting to the point where they can effectively tell governments what to do, and the role where they become the handmaidens of governments by buying government favors through the trading of personal data on this roundabout that we are now seeing. I don't know if this answers your question, but hopefully it's getting close.
Yes, it surely does. Thank you very much again, Judith. So I will jump to the other questions so we profit time. There's two questions concerning safeguards, so how to guarantee human rights. So the first question concerning facial recognition and public security. And the second one, the person mentions the UBA issue in Germany, so labor rights. So safeguards, human rights safeguards concerning both public security in the first place and second place labor rights. The two persons want to hear you a little bit about these issues concerning digital rights in these subjects.
Okay, yeah, I think in both cases, I want to go back to what I said during the presentation about going deeper than we are allowed to if we stick with the tried and tested metaphors. So I think without trying to shy away from these two specific, case studies that you've given me, the facial recognition and the Uber cases, the employment rights. I think what they both have in common is that, again, we are accepting something as a given, and we're then tinkering on the edges. Or that is at least what we are encouraged to do. We are encouraged to accept facial recognition because it is now there, it is now here. It's a technology. We're going to use it. There is no way about it. So let's now make sure that we use it in the most societally friendly, humane way, ethical way, and so on and so on. And the same with Uber. It is a business model that is now there, and let's regulate it so that it can actually work, that it is possible. And what I would like to encourage people to do, and the answer doesn't always have to be no or yes, the answer isn't always predetermined, but I would like people to go this further step and to say, but do we need this? Is this what we want? And I think, we have asked, as humanity, we have asked ourselves these questions with regard to certain types of innovation over the last centuries. When you look at nuclear armament or the use of nuclear power, there has been a very significant and very fundamental question asked, as in, should this be used? On what conditions should this be used? By whom should this be used? And in reverse, by whom should this not be used? In what conditions should it not be used? When should it be prohibited? Similarly, if we're looking at things like, stem cell research, however you want to feel about it, and, you can be on either side of it. But what I'm trying to say here is it is a fundamental question that as humanity, we have asked ourselves, and we have discussions about. Helping people to die, ethical questions like that, okay? We are asking ourselves, is this something that we as the human race, as a society want to do? Is it something that we want to allow that the use of? Is it something that we should prohibit? We've been having these fundamental discussions, and we've used something called the precautionary principle in many cases. So until we know that something that is potentially dangerous isn't safe, we haven't allowed people to use it, okay? So this is to a certain extent what we're currently doing with the autonomous vehicles. Until we can absolutely be certain that we can let them on the road without them killing a lot of people, we will not license those electric vehicles. But in many other areas, we are not asking these fundamental questions. And I think one area is, for instance, facial recognition. Another area where we are seeing this in Europe as well, but also in other countries, is AI. Europe is currently discussing a proposal for an AI Act, an AI regulation, which does actually have one section. So it does try. It has one section where it basically says, these uses of AI are a no-go. You shouldn't be doing this. This is prohibited. Okay. And then it has a very, very much longer list where it says, well, these are uses where, we have some concerns, so you can only use them subject to these safeguards. And I think, both of these lists are subject to discussion. But we need to have an awareness that those lists should both exist. And we should not be going into regulating AI by saying it is generally allowed to do this, and here are the safeguards. And I think the same thing can be said definitely with regard to facial recognition. There are really, really good reasons why facial recognition, if used in any kind of way, will change society in a way that we have currently no way of anticipating, okay? It changes all of us. It changes our perception of ourselves, of each other. It changes power relationships between individuals and the state, individuals and companies. It changes a lot. And from the precautionary principle, we would really have to argue now, and we have to ask ourselves the question, should we be doing this? Or should we actually say, this is a step too far. This is not a technology that should be possible to just be used willy-nilly by everybody. But again, we are confronted with this narrative, with this framing at the moment, that all innovation is per se, in the first instance, a good thing. And that anybody who says, well, you shouldn't be doing this is counter-regulation, counter-innovation. I am not counter-innovation. But I want to be able to have a discussion in the way the societies have always had discussions about whether something new actually works for us, or whether the risk of it working against us is too big.
Thanks again, Judith. It's very good to hear you. So many times it's very frustrating just to be confronted to these situations where we don't see that too much. We don't see those fundamental questions being posed. So assuming that it is as it is, and we act. Or I don't know if it's really an action or being like moved by some kind of external force without good reflection. So, but not to be very pessimistic, let's keep on. And please, we have 3 minutes left. So, if you could please wrap up with your final considerations.
Okay. Yeah, I think I'm looking at the questions again that I didn't have time for and that were there, and I think I'd like to go back essentially to the conclusions of my presentation, and would like to encourage people. As I say, I come from an academic background. That's where I worked for the last 15 years, and I've now moved over to a civil society background because I wanted to be closer to basically making actual change. And I think what I would like to really do is to just say to any audience that I work with the same thing that I used to say to my students, which is think, which is, don't accept what you're being told at all times. Don't accept assumptions. Don't accept framings. Challenge framings. And I think as far as data protection as a human right is concerned, there is a lot of work to be done. And I don't expect this to be done within the next 5 years or even within the next 15 years. I think this is a long-term strategy in the same way as it's taken us from the 70s to get to where we are now. But I think the challenges that we have ahead now are bigger than what they were back then, partly because the difference in speed that we are observing between innovation and new technologies, development of new technologies, that's getting faster and faster all the time. And law is as slow as it ever was. And it potentially is slower because there is now the need for increased international cooperation. There is now an increased friction between different cultural attitudes and so on and so on. And I think the recommendation, the suggestion, the proposal that I would like to end up with is actually to really look at things with fresh perspectives, try to look at it not just from your own perspective. So this is something that we're really learning in the decolonization work as well, to just basically look at it from other people's perspective, and then work with each other in trying to get a regulatory framework that actually ensures that technology works for society and humanity rather than the other way around. Because the other way around is where dystopia lies. And we have recently had a really interesting seminar where we learned that communication actually needs to be hope-based. We need to be able to envisage, to imagine the future that we want to see, rather than just warning of the future that we fear. And I think this is in a way that has really influenced the way I'm going to go about this in the future. So let's imagine the future that we want to see, and then let's try and make it happen. Thank you.
Thank you again, Judith. It was a very nice, big pleasure to have with us this afternoon. So we finish our panel now. Next panel is about the use of technologies in public security at 4 o'clock, so in 23 minutes. Thanks again, and good afternoon for everybody.